Mhm. एक मिनट. Nature and definition of tort. The word tort has been derived from the Latin term tortum, which means to twist. It includes the conduct, which is not straight or lawful, but on the other hand, twisted, crooked, or unlawful. It is equivalent to English term wrong. This branch of law consists of various torts or wrongful acts whereby the wrongdoers violate some legal right vested in another person. The law imposes a duty to respect the legal right vested in the members of the society, and the person making a breach of that duty is said to have done the wrongful act. As a crime is a wrongful act which result from the breach of duty recognized by the criminal law. A breach of contract is the non-performance of duty undertaken by the party to a contract. Similarly, tort is a breach of duty recognized under the law of the tort. For example, violation of duty to injure the reputation of else someone else result in the tort of defamation. Violation of duty not to interfere with the possession of land of another person result in the tort of trespass to the land with the violations of duty not to defraud another results in the tort of deceit. So far, no scientific definition has been possible which could mention certain specific elements, the presence of which could constitute a tort. As an example, it has been possible in some cases in case of a contract. The main reason for the same is the different wrongs included under this head are diverse species, each having its own peculiar historical background. Most of the tortoise wrongs owes their origin to the writ of trespass. Writ of trespass on the case. These writ were not only responsible for origins of the branch of law, but many other wrongs and legal principles also originated from them. The law of contract, for instance, is practically a gift of these writs. Apart from that, many torts had their original independently of these writs, and the developments has been fragmentary and piecemeal. As a matter of fact, it is ever-growing branch of law and has constantly developed. The area covered in its ambit is continuously increasing. Some definition of tort. Tort means a civil wrong which is exclusively a breach of contract or a breach of trust. The Limitation Act 1963. It is civil wrong for which remedy is a common law action for unliquidated damages and which is not exclusively breach of contract or the breach of the trust or the other merely equitable obligation. Salmo. Tortious liability arises from the breach of duty primarily fixed by the law. This duty is towards person generally its breach is redressable by an action for unliquidated damages when filled. It is an infringement of the right in realm of a private individual giving a right of compensation at the suit of injured party. Fraser. The basic idea which indicated by this definition is firstly, tort is a civil wrong, and secondly, every civil wrong is not a tort. There are others wrong also important of which breach of contract trust. हाँ बोला